Okay, welcome. We're going to open the meeting. I want Mr. Pizzo to announce that we were having a meeting prior to this. That's where we were. We had an executive session. Do you want to announce that, Mr. Pizzo?
Yes. An executive session was held immediately prior to this evening's council meeting for about an hour. Members of council, the mayor, the director of administration, Mr. Ferris, and I were present. Two matters were discussed. One matter involving real estate, and the other involving pending litigation. No official action was taken on the real estate matter, and no action is required this evening. No official action was taken on the matter of litigation. There will be action later this evening in regard to the matter of litigation as it involves the Township Local Gaming Device Ordinance.
I just wanted to explain real quick because we're running about 5 minutes late. We're going to open up the meeting with a moment of silent meditation or prayer, followed by the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so this evening, our January 27th meeting is the first of the year. The other one was canceled, our first official meeting, regular council meeting. I just wanted to introduce our fellow council people. I have our vice chair, our vice president, Ed Kisselback, our secretary, Michelle Benitez, our council members, Joe Clary and Stacy Champion. Okay, so, and we have Debbie and Phil Worses, our engineer, and then the mayor, of course, and our council, Joe Pizzo, and Ken Farrell. Is it Farrell? It's very close to the other name, right? Okay, very close. Is here this evening. Okay, so we have public comment on agenda items only. If someone wants to speak on the one of the agenda items, we'll give you an opportunity as the agendas also come up. So we'll close that out. Okay, approval of council minutes for our previous meetings. The first one will be November 25th, 2024. I looked at these myself, but does anybody have any changes for the November 25th, 2024 meeting that Mr. Kisselback was running at the time?
I'll make a motion to approve as submitted.
Okay, we have a motion to accept the minutes for November 25th. Is there a second?
I'll second.
Okay, there's a second. All in favor, say aye.
Aye.
Any against? Okay, so they're accepted. Okay, our December 2nd, 2024 budget meeting. Is there any changes that any of the council members would like to consider or have done?
I have one, it's just typographical, an indication from the
What page?
page 3.
Okay.
My comment on mid-page, township was fairly confident
Okay.
that funds be relocated. The typo was barely. I just want to be clear that I wasn't implying that we're not confident in what the discussion was.
Okay, so you want to say confident as opposed to barely confident?
Fairly.
Oh, fairly confident,
Yeah,
okay.
I think it's just a typo.
Okay, instead of barely.
Thank you.
Okay, you'll fix that right then. Okay, it's probably a typo, but that's okay. Okay, is there anything, other changes? Is there barely any changes? Anybody else changes? No? Okay. I'm not hearing any changes. Is there a motion to accept the minutes with the one typo? Ms. Benitez has requested for December 2nd. Is there a motion to accept the minutes for the budget meeting?
I'll make a motion to accept the minutes for the budget meeting.
Okay, is there a second?
I'll second.
Okay, all in favor, say aye.
Aye.
Any against? Okay, so we're good. Sustained, that's, okay?
Abstain.
Abstained. Okay? And the next one is January 6th. January 6th. Minutes for the reorganization meeting. January 6th.
Make a motion.
As the members are present, any changes? Okay, is there a motion to accept the minutes for January 6th reorganization meeting?
So move.
Second.
Second, okay, all in favor?
Aye.
Any against? Okay, thank you. Okay, consideration, number 5 on the agenda, consideration approval of ordinance for amending Chapter 134, local gaming devices of the Township Code, amending Chapter 160, peace and good order of the Township Code. And part of this was our discussion that we had about this, the particulars of this with our legal team. Joe, do you want to take this, or?
Certainly. Thank you, Mr. Knowles. And as the agenda reflects, it's amending the ordinance that established Chapter 134, local gaming devices, and amending Chapter 160, peace and good order. I should note that this amendment was properly advertised in the Bucks County Courier-Times on January 19. As council was briefed during the executive session, when council adopted ordinance 2024-05, which is known as the local gaming device ordinance, back in October of last year, that adoption was followed by litigation that was brought by a business that is involved in the local gaming device, or skill games as they're sometimes referred to, skill game business, as well as one of the local businesses in which several of these machines are located. That litigation has been moving through the Court of Common Pleas of Bucks County. One of the arguments that's been raised by the plaintiffs is in regard to the township's references in our local gaming device ordinance to the Pennsylvania Crimes Code, and specifically to 18 Purdon's Section 5503. 5513, I'm sorry, 5513 of the Crimes Code. And that section, as council has been made aware, essentially makes it illegal for individuals or businesses to operate games of skill unless they are licensed by the state to do so. It would otherwise amount to illegal gambling. Games of chance. It would illegal to operate games of chance. So in the original drafts of our ordinance, we included references to the Pennsylvania Crimes Code and specifically to Section 5513, both in defining the devices that would be subject to the ordinance, and there are a number of them, not just those defined in Section 5513 of the Crimes Code. And further, we included references to the criminal prosecutions that might follow by making possessing any of the devices that are defined in our ordinance a violation of Section 5513 of the Crime Code. As I said, as the litigation has played out, and reviewing the way the township has been enforcing the ordinance to date, the township has not found it necessary to move forward in any fashion with any actions under the Crimes Code. All of the enforcement actions to date by the township have been of the civil variety, as outlined in Section 134.5 of the ordinance, and those have involved notices to the property owners or the businesses that the machines have to be removed, and in one case, a notice of violation having been issued to one of the businesses. There's been no criminal activity, there's been no criminal prosecution. And so, since the issue was raised by the plaintiffs in the litigation, and since the enforcement of the ordinance hasn't necessitated proceeding in that fashion, it's our recommendation to the council that at this time, we should simply remove the references in our ordinance to Section 18, Purdon's 5513. And in doing so, we believe that we will essentially take away the strongest argument against our ordinance, that we are somehow criminalizing something that the state otherwise hasn't. We don't believe we have. But, again, since these sections of the ordinance, as things played out over the last several months, really haven't been germane to the way the ordinance is being enforced, it's our recommendation that we take them out at this time, taking away that argument from the court as we move forward in the defense of the litigation. And so it's our recommendation that, as set forth in the ordinance before you, amending 2024-05, that Section 134-5, capital C, 134-5 capital D, and 160 subsection 16, 160-1 subsection 16, as are set forth in the ordinance before you, that those all be stricken from the code of the township. Additionally, not included in that ordinance, but as we discussed with you this evening, and again, as things continue to happen in real time in our defense of this ordinance on behalf of the township, it would also be our recommendation at this time that the township delete section 134-2, subsection 1, subsection small e, from ordinance 2024-05. That section, which is the definition sections of what constitutes a local gaming device, currently reads an electronic video monitor, as that term is defined in Pennsylvania Crimes Code, section 18 PACS, section 5513, and/or that operates and/or is operated as defined and described in the Pennsylvania Crimes Code, 18 PACS, section 5513. It's our recommendation that in addition to the other amendments, that subsection of ordinance 2024-05 also be stricken as part of council's action this evening. And if you're in agreement with that, then we will amend the ordinance to reflect that action this evening. Council, as you know, you can make an amendment this evening that isn't part of the published ordinance if you are removing something or making the ordinance less restrictive. If you were going the opposite way, then we'd have to re-advertise. But in this case, if you follow our recommendation and also take out that reference to 134-2 sub 1 sub e, then you can do that this evening as well. So I apologize for the long-winded explanation of what's happening, but I thought it was important that the public understand that we're not doing this because we got it wrong. Township's doing this because you've been confronted with a lawsuit that challenges the legality of your ordinance. And in defending that, we believe that by taking away an argument that even though we believe the township would ultimately prevail, it's not necessary to fight this particular fight at this time. And it makes more sense to simply remove those references to the crimes code from the ordinance.
Okay. So as we discussed, our code enforcement is the one that's actually enforcing this type of
correct. All of the enforcement action at this point has been through the township's Department of Building and Planning. Inspections, as you're aware, inspections determining where the machines are located are permitted to be done by the police, are permitted to be done by the fire inspectors, are permitted to be done by the code inspectors.
Okay.
All of them have the ability to do the inspections, and we're not changing that. But we will at this point be limiting the enforcement actions to and through the Department of Building and Planning and through the district magistrate courts.
Okay, and then we'll just, when we get to a point where we make a motion, just make sure we're making a motion to remove the proper sections that we discussed. Does anybody have any questions for Mr. Pizzo or?
I do.
Okay.
Mr. Pizzo, when we talked about this originally back in October, we had discussed security. What kind of security is going to be on the premises for this? You go to the casino, they have security. People are gambling, people get upset. You've got people shopping and doing things in these places. Is there anything in this approval that covers security?
An excellent question, Mr. Polari. As you're aware, the ordinance itself prohibits the local gaming devices from all businesses in the township, save for, excuse me, those that have current and valid licenses issued by the Pennsylvania Liquor Control Board, either for businesses that are a restaurant liquor license, a brewery liquor license, a distillery liquor license, a winery liquor license, or a brew pub license. And those licenses have to be in good standing with the LCB. The other locations where these devices would be permitted are establishments that hold active club liquor licenses, such as the Knights of Columbus or the VFW or American Legion. In those places where they are permitted to have the machines, the numbers are limited, 3 for the restaurant and brewery liquor license category, 5 for the local clubs. And secondly, what those businesses have to do in order to have the machines in their establishments is they have to establish a segregated location within their facility where the machines are not accessible to children. They have to be in view at all times to one of the people in the business, typically a bartender if it's in a bar, or someone who's an employee who will have constant eyes on the area where the machines are located. And thirdly, the ordinance requires them to install closed-circuit television monitoring of the areas, and that the video or film for those cameras have to be maintained for a period of at least 30 days and have to be accessible on demand to the Bensalem Police Department. So those are the security measures that are in place for the machines that are permitted to be in the township. Otherwise, the machines aren't permitted to be in the smoke shop, the gas stations, the pizza parlors, the places where we're seeing the proliferation of these machines within the township, and places where, candidly, the township never envisioned them to be located, particularly in the numbers that we're seeing them.
But we're allowing them in restaurants where families go to the restaurants and their children in the restaurants. Somebody gets angry because he or she is drunk and they've got a weapon on them and they start causing trouble. There's no security on the premise that has these to protect the family members that are there. We have to depend on our police force to go there and hope that they get there in enough time to stop it. Is that what's being said?
I don't know if I would say it exactly the way you're saying it, but I would say that in those businesses where the township said they are permitted to be located, businesses that otherwise have to comply with all of the regulations of the Pennsylvania Liquor Control Board to maintain in good standing their liquor licenses, including not allowing for various kinds of activity to take place, particularly minors having access to the areas where liquor are. The thought was that as to those businesses that already have to comply with the regulations of the state to maintain their licenses in good standing, those were the places where, again, in limited numbers, 3 and 5 respectively, machines could continue to be located in those businesses. Going forward, and I know you were a proponent at the time of the hearing on 2024, that they should be banned throughout the township. That is, of course, a route that the township can go if collectively you all feel that, you know, it's not working out, even allowing them in limited numbers in the places that have liquor licenses. We want them out of the township completely. That's always an option that is available to you, certainly.
Is the state putting together laws on this type of thing?
A bill was introduced in the last session of the state Senate, and of course, as I shouldn't say everyone's aware, but the last session of the state legislature ended shortly following the November elections. So a new Senate has been sworn in, a new state House has been sworn in just within the last several weeks. I don't know if the legislation that was introduced in the last session has yet been reintroduced. But no, nothing has been officially enacted by the state legislature and or signed into law by the governor.
My concern is if somebody, God forbid, a child gets killed, hurt, or anybody in this township on an ordinance that we passed and not demanding security, protect people from that, it would be very difficult for me to live with that if somebody gets killed because of a gaming device. And in this world today where we are with the stress and everything going on, it's just taking a chance of something bad happening. It may never happen, and I would pray it wouldn't happen, but I don't know that I can put my name on something, agreeing to something that puts us in that and puts me in harm's way, because personally I would have a hard time dealing with myself.
Well, as you know and as you all know, you collectively and unanimously adopted this ordinance in furtherance of the health, safety, and welfare of this community and its residents. That is the underlying purpose for this ordinance in the first place. It's certainly our belief that, and as was stated at the time of the initial adoption of the ordinance, that what we were recommending to you was something that was consistent with legislation that had been introduced in the State House to address the question of local gaming devices going forward, that was consistent with what the city of Philadelphia was doing at the same time in regard to the proliferation of these devices in the city and the various problems that the proliferation of these devices was bringing upon communities throughout the Commonwealth. Again, it was our belief that the presence of the liquor license and everything that a business that either that a local bar or restaurant has to comply with in order to maintain their license in good standing, and particularly that the devices had to be segregated within those facilities so they weren't accessible to the general public, specifically children, and that they were otherwise able to be monitored, if not controlled. Excuse me. That course of action was a reasonable compromise, if you will, so as not to perhaps unnecessarily restrict or prohibit these devices throughout the township. But to your point, if it's the collective concern of the township, or as we're moving forward with the enforcement of this ordinance, if council believes that, no, it's just not working, we thought that allowing them in limited numbers was something that we could do, but no, the problem still exists and it's not getting better, council certainly has the ability to come back and direct us to further amend the ordinance to simply prohibit them throughout the township, period.
Well,
May I
I think we're
comment?
trying to.
I have another question, let me
Yeah, go ahead.
finish.
Okay.
Is there anything in the Liquor Control Board and in their legislation that talks about these machines, and with them saying that there has to be security? I understand you're saying that they have to have a liquor license, but are these type of things approved in the with the Liquor Control Board, that they're covered, or is this just saying we're adding to that? And if Ken has to tell me something, that's fine.
I don't believe that the liquor code per se speaks to whether or not these devices are or are not permitted within a licensed establishment. Again, it's how these, I could really go for some water if anybody has a bottle that isn't open.
I have a bottle.
And while you're getting a drink, I'll just tell you why I'm asking that question. Because we're approving this, and the Liquor Control Board doesn't approve this, and something happens, are we liable for, can we be sued because we approved something that wasn't approved by the Liquor Control Board, but we put it as part of our thing that they had to have licensed by the Liquor Control Board?
Well,
I'm just trying to be.
I understand. And can you be sued? In fact, you have been sued. Even with carving out the restaurants and the VFWs and the Knights of Columbus, even with that, you've been sued. Township, unfortunately, township is always a target when it comes to litigation. Again, in crafting this ordinance, and there were many months, if not years, that went into it. Part of what we did, as was discussed back in October, was to mirror that legislation that had been introduced in the state in the hope and expectation that the state would in fact act on it, and that you would have an ordinance that was already compatible to the law that was being introduced in the state. The bill that had been introduced allowed for the machines in limited numbers in the same kinds of facilities that are licensed and governed by the State Liquor Control Board. And so that, and again, looking to what Philadelphia was doing on a similar scale to address the problem, put us, we believed, in a defensible position that what we were doing wasn't going beyond that which was being discussed or proposed in Harrisburg, or that which was being discussed and proposed in the city of Philadelphia. But you can all, I can't underscore this enough, you can all turn around and just say, Mr. Paizo, prepare another amendment, bring it forward that prohibits them throughout the township, if that's collectively what you believe to be in the best interest of the township. Your ordinance was reviewed and discussed and commented on by the county district attorney. It was reviewed and discussed and commented on, in many cases formulated in collaboration with the Director of Public Safety and his command staff, based on what they were seeing, what they were dealing with boots on the ground, real time in the township as to what was happening in gas stations, what was happening when these devices were being played, when the money was being collected, the possibilities for, the crime related to the use, operation of these machines in places that candidly the township never intended for them to be. 7 or 8 of them in a gas station up on Route 1, where the player can leave and go out and make up his losses on an unsuspecting resident at a gas pump, or make up his losses at the cash register by pointing, something at the gentleman working the cash register. The same concern, or the same fear, if you will, wasn't necessarily present in these licensed establishments under the regulations that the township was proposing. But ultimately, the 5 of you are charged with the health, safety, and welfare of the community. And so if it's your belief that this ordinance doesn't go far enough, we'll take it farther.
I have one other comment, and nothing you're going to have to answer, it's just my comment. I believe that this also puts our police department in a position where they're going to have more problems and more things and more safety issues when they're already busy enough now, that because we're right on the outskirts of Philadelphia, and a lot of that crime in Philadelphia makes its way up here, that we put our police department in harm's way. And it also puts our residents in harm's way if the police are too busy taking care of that and not available to take care of other crimes that come in. So they're just concerns of mine, and I just want to get answers on it now on the record, and I appreciate it. Thank you.
All right, thank you.
May I make a
Michelle,
comment?
do you have something?
Yeah, I think the skill games have been at those facilities that we're not approving, we're just not limiting to an extent with this ordinance for many years beyond what we're dealing with today in today's time, where we're seeing at establishments that we wouldn't expect them to be. My recollection of the presentation from District Attorney Shorn and Director McVeigh was that through their investigation over the course of the 2 years, this was their recommendation. So I'm very confident in their investigative skills, and I'm happy with their recommendation. I'll go with that. In addition to that, Senator Farry is the one who brought the bill forward. I'm going to say it was 4412. PSATs is coming up in May, and this is a resolution that may be coming up in state, but I can further investigate that and talk to you more about what I'm seeing. I will be attending PSATs this year. As far as any resolutions coming forward, that would come out of Bucks. That's something that we can discuss at the
Okay.
state level and get more
Okay,
information.
my only point would be, we already passed this, and all we're doing is amending this to hope that it survives the legal battle that it's already going to face, that the ones facing Philadelphia now that may have a decision soon. So we're amending it to make it possible that we at least can do what we already did. In the future, if we choose in the future, like Mr. Polari said, and I don't disagree with Mr. Polari's points, that we want to make this tougher, or once it passes this level of being able to do anything, then we can do that in the future. But for now, all we're doing is amending something that already passed. We already made it ordinance, we already voted on it, and we're just amending this to make it a little bit easier to fight this in court, and at least and be able to have the ordinance the way it's written now. We want to make it tougher in the future. We want to remove it from restaurants and bars and clubs and stuff in the future. We can do another round of this, and if we get away with this, legally we can get this passed and have this stand up in court, then we can look at making it tougher if we choose to do so.
It is also consistent with other municipalities across the state.
Yeah.
So
Yeah.
there's power numbers.
Okay.
I'd like to add to
Yeah.
the conversation that if the choice that we had was to have only gambling and gaming done in the Park Casino in Bensalem, that would certainly be my choice also. However, what happened was we got caught off guard, and before we knew it, we had these little games of skill or chance, and I'll bring it up in a second, showing up at places that they shouldn't be, such as gas stations and smoke shops, and pizza parlors and delicatessens. So every time you would turn around, you see no one's popping up, and so you had to take some type of action. I believe if, in fact, if the choice was to eliminate them completely from being part of the environment of Bensalem, I think it would be almost indefensible in terms of going to court and them, the gaming industry, suing us for not allowing them to have those type of businesses in Bensalem. This way, we have the control with them, and it's controlled by the LTB, the Control Board, and limit it to either being in like a bar and restaurant and or a social club, based on them having the liquor license, and they would be subject to them possibly losing their license. The ordinance that that's being presented to us is almost a carbon copy of what is being presented up in Harrisburg. Now, whether it would be passed in Harrisburg or not, it's identical to that, so we don't have to worry about it being completely different. Presently, we are being sued, as Mr. Pizzo said, on a technicality by a word. And this is how minute they become in terms of suing us. And if we'd had them not allow them to be part of the environment of Bensalem Township in the controlled environment, they're suing us now by the nomenclature of either being a skill game or a game of chance, and they're differentiating the difference between the two. And so this is one of the changes that we're making so we can address that aspect of it, so we're not caught in a bad position. So again, my position would be, if the choice was, and I know we're going to court with it, and I do believe we would lose it, but if the choice was not to have any of those type of establishments, or games of chance, games of skill, throughout Bensalem, I would vote 100% not to have them. But this being a limited, controlled inducement through the industry itself, we feel that we're giving them the possibility of them moving along in that field, as well as addressing the problem at hand. As Mr. Pizzo said, being in restaurants, we understand there's children there, but there's going to be a specific section in a bar or a restaurant or even a social club that's has to be roped off and monitored. So it's going to be certainly controlled in a minor type of way, and I think we have a better chance in court of surviving any questions on these issues. So that's my position.
Okay, the question today is just, do we want to amend this ordinance as suggested by our legal counsel? So, does anybody, do you want to say something about it, or I don't want to relitigate the
No.
ordinance.
I'm
Okay.
going to say I agree with all, I agree with Mr. Larry and Mr. Kisselback. In terms of this, until we had that meeting that evening, I had no idea, or the number of these within our township, and thought about it as you're going to get your gas, and there are people there that you do not know who are there necessarily in there. I agree with Mr. Kisselback in terms of, in most restaurants and or bars, you have your regulars, your bartenders know, and if they're keeping an eye on them. They also know when their patrons have had too much to drink and such, and we'll take care of that. So I think that we have a sense, it's not the ultimate control that Mr. Laird like, but I do believe that we have eyes always on the patrons, more so in a bar situation. So on the fear of losing your liquor control license because of activities in your bar outside of, not inclusive of this, but other things, is more worrisome to them. So I am glad that we are approaching this to ensure that this continues to be able to be enforced in those areas that members of the public would potentially happenstance in on something that could potentially be more dangerous.
Okay, so again, what we're doing tonight is amending the ordinance that already passed to eliminate 3 paragraphs that'll make it easier to stand up in court the way it's written. If we want to change it later and try to get stricter about it, we can cross that bridge when we come to it. Let's see if later this passes the mustard in court first, and then if we need to get tougher on it, we can get tougher on it. We have that option. Does someone want to make a motion that we approve the removal of the 3 sections that Mr. Pizzo has advised as our legal counsel?
I'll put a motion
for
on
the
the floor,
ordinance?
Mr. President. I'll put a motion on the floor that we approve the ordinance amending Chapter 132, 134, local gaming devices, Township Code, amending 160, peace and good order for the township. And as I go through my notes here, I have 134-2 definitions. We would eliminate, if I can get this right, 134-2-1E, which has to do with electronic video monitors. We also eliminate from the current ordinance, Section 134-5, violations and penalties, and there will be subsections of C, peace and good order, D, crimes code, C, which is peace and good order also, Chapter 160, and that would be my motion.
Is that correct, Mr. Pizzo, or correct?
Yes, so in the ordinance that's before you as advertised, all of the sections that are, the amendments that are outlined in that ordinance would be approved, and in addition to everything that's in the advertised ordinance, also the deletion from the ordinance as part of Mr. Kisselbeck's motion from section 134-2, subsection 1, subsection E, having to do with electronic video monitors as defined in 18 Persons 5513. That would be the additional amendment beyond that, which is already set forth in the advertised ordinance.
We're okay passing this with public comment, right?
No, you do need to take
Ordinance.
Okay,
public
does,
comment.
Yes.
okay, yeah. Does anybody that wants, before we do a second vote on this, does anybody that wants to comment on our discussion or the amendments that we're making? Okay, yeah, well, I'm giving an opportunity now, so. Okay, seeing no one come forward, is there a second motion?
I'll second the motion.
Okay, all in favor, say aye. Aye. And against?
Aye.
Nay, okay, so you don't want it amended? Okay, and then, okay, so we have 4-1, Joe. We're amending the ordinance. Okay, so next on the agenda is item number 6, which is the, broken down two, we have 6 and 7 actually, which both are Ken Fleck, 2975 Galway Road. We have a zoning change from general industrial to light industrial to make the two lots consistent. And then the second thing on number 7, we have allotment change. Okay, so is there someone here representing the applicant?
Stephanie Coble, Fitzpatrick Clinton Buba, on behalf of the applicant.
Mr. Knowles, based on what you were saying, I just want to confirm that, as is consistent with the way council typically deals with rezoning requests that are otherwise tied to some other action, be it a lot line change, a subdivision, or a land development, that the hearing that you're about to hold will be contemporaneous on both items 6 and 7.
Okay.
You'll do separate motions at one on the rezoning and one on the lot line change.
Yeah.
But for the effort of clarity and so that there's not, you're listening to the same presentation twice, this presentation will be for both items 6 and 7.
Okay, I appreciate that, because I was going to do it that way, but I wanted to make sure I was able to do that. Okay, so that's good. So we can handle both 6 and 7. 6 would be the actual changing from general industrial to light industrial for the one lot. So they would match. It would be one big light industrial lot on the right side of the property facing, and then also the actual lot line change.
That's correct.
Okay, go ahead.
And if I may, before I start, can I approach and pass out my exhibit package?
Yeah, Ms.
Thank you.
Oh, you have another packet. We got a lot of paperwork on this one. Okay.
I felt like I didn't give you enough last time.
Well, we got enough. I printed out what you sent over this afternoon, too.
Oh, it's duplicated out.
Okay, good. Okay, good. All right, this is what I printed out, yeah.
Yep.
While those are
You have
being
the notices and everything, right, John?
While those are being handed out, I should note that this evening's hearing is a continuation of a hearing that had been duly advertised previously and continued either at the request of the applicant, at the request of the township, or by virtue of the township having canceled one or more meetings in the intervening period of time, such that we find ourselves here this evening on both matters. But the underlying application was properly advertised, notices were properly sent out, and the township has properly advised the public of the continuation of the matter through to tonight's hearing.
Okay. And just to clarify for the public and for the people in the audience, we're not approving anything be built or anything be developed on these lots. What we're doing is we're making a lot line change, and then we're changing, per our request actually, that the entire right side of the property be light industrial, as opposed to being half of it being general industrial, which would have allowed, in our estimation, harsher uses. But go ahead.
That is correct. Tonight, there's no land development planned. It's a lot line adjustment, lot consolidation, and actually a downzoning of a portion of the southern lot so that the southern lot is all one zoning, which is done at your request.
Okay.
One thing I would like to request the indulgence of the board, I have two witnesses with me tonight whom I'll introduce both of them very shortly. I would like to go through the questioning of both only because what I found too often is I go through one, people start asking questions, and my answer is, well, the second witness was going to talk about that. They will both be available and will answer any questions that you have or anyone in the audience has. Is that
Okay.
acceptable?
Yes.
Okay, thank you.
Mr. Knowles,
you
that
need
might
to
be
introduce
an
them as-
appropriate time to just have them sworn.
Yeah. Can you swear them in as witnesses and with their expertise?
Can you raise your right hands, please? Do you solemnly swear the testimony you're about to give will be true, the whole truth, and nothing but?
And could you identify them for us, please?
Yes, I will.
And
I
their
will-
areas of expertise?
Yes, absolutely, and we'll ask each to introduce themselves at the start of their testimony as well.
Okay.
Good evening. As I said, my name is Stephanie Coble. I'm an attorney with Fitzpatrick and Buba, and I represent the applicant Full Pen 2 LLC, which owns the property at issue located at 2975 Galloway Road, Bensalem Township, Bucks County. It's actually 4 different PIN numbers. With me tonight, I have Don Barra, who is a professional land surveyor with Barry Isaac Engineering, and Ken Fleck, who is a representative of Full Pen 2 and Foley Cat, the operator at the site. Before our representatives provide testimony, I just wanted to refresh Township Council with some background, and I think Mr. Pizzo did a fairly good, pretty darn good job of this actually, but just wanted to go through it. Full Pen acquired these 4 parcels of property on January 12th, 2023. That's evidenced by deed, which is in your packet marked A1. On the 2 northern parcels, Full Pen operates a Foley Cat sales and service facility, and the 2 southern parcels are vacant. Earlier this year, Full Pen submitted a lot line adjustment, lot consolidation to the plan, seeking to adjust the lot line between the northern and southern 2 parcels so it follows the zoning boundary, and consolidate the 2 northern and 2 southern parcels. So the end result would be 1 northern parcel, 1 southern parcel. The lot line consolidation is in your packet, and just for historical references, marked as A2. On May 20th, 2014, we appeared before Township Council on this request. At that meeting, the primary concern of the Township Council was the fact that the lot consolidation would result in the southern parcel being split zoned. 1/2 general industrial, 1/2 light industrial, and requested that the applicant consider downzoning the southern parcel so all of it was zoned light industrial. The applicant agreed to consider that request and subsequently submitted its rezoning request to rezone the entire southern parcel as light industrial. I've included a copy of that for your reference as well as Exhibit A3. This rezoning request was submitted to the Bucks County Planning Commission, which issued a review letter dated September 4th, 2024. That's also in your packet and marked as Exhibit A4 under tab 4. The County Planning Commission commented that the rezoning request is compatible with the Township Comprehensive Plan, is consistent with existing development, and will have minimal impacts on adjacent land uses. On September 18th, 2024, the Planning Commission provided a positive recommendation on the rezoning request. The matter was, as Mr. Pizzo said, on 3 previous Township Council meetings, and was postponed to date certain via announcement at each of those meetings. I joked with my client that if there was a major snowstorm tonight, I was getting down here come you know what. At this point, I'd like to introduce my first witness to explain the rezoning and the lot line adjustment consolidation and why both requests are appropriate. Mr. Barra, can you state your name for the record?
Arnold Joseph Barra,
And by whom are you employed?
Barry Isaac and Associates.
And what is your job title there?
I'm the department head of the Land Surveying Division.
And can you just provide a brief summary of your professional credentials to the board?
Yes, I'm a licensed land surveyor in Pennsylvania, Ohio, and West Virginia. Been in the profession for 25 years. Been licensed for 10 years. And have led survey departments at numerous engineering firms.
And have you testified in other lot consolidation, lot line adjustment matters as an expert in land surveying?
Yes.
At this point, I would like Mr. Barrett to be considered an expert in land surveying. I think he has the credentials and
Okay, we'll
qualifications. Thank you. Is Barry Isaac the land surveyor for this project?
Yes.
As the land surveyor for this project, did you send out notices to neighboring properties alerting them to this proceeding?
Yes.
And did you send it prior to the earlier proceedings that were continued on the record?
Yes.
If you look at Exhibit A5, are these true and correct copies of the notices and proofs of mailing that you sent out?
Yes.
Okay. Can you tell the board where the properties at issue are located?
It's located on the western side of Galloway Road.
And what's the current use of the property?
The northern parcel is Full Cat's equipment yard, and the southern parcel is vacant.
And can you show on the plan that's up?
Excuse me. I'm not a geologist or anything, but is that on the western side of Galloway Road? Is that correct?
Eastern side?
Eastern side.
Okay, I think so.
Yeah,
Okay. Thank you, Phil. Thank you very much.
did you say western?
Did I? I'm sorry, eastern.
Okay.
Okay.
Thank you for that correction. Can you, using the plan that's up, show the northern portion that's developed with the Foley Cat franchise?
The northern portion would be in this area.
Okay?
Is that a question or is that an answer?
This is the northern portion that we're referencing.
Right.
And that's the portion that is developed with the Foley Cat franchise, correct?
Correct.
Thank you. And is the applicant today seeking the following relief? Consolidation of the 2 northern parcels and the 2 southern parcels? Is that correct?
That is correct.
And they're seeking to adjust the lot line between the northern and southern parcel to coincide with the zoning line? Is that correct?
That is correct.
And they're seeking to change the zoning of approximately 26 acres of land on the southern parcel from general industrial to light industrial. Is that correct?
Yes.
Did you prepare the plan showing both the proposed rezoning along with the associated lot consolidation?
Yes.
I'd like to have you look at Exhibit A6. Is that, excuse me, is that a true and correct colorized plan of the lot line adjustment plan?
Yes, it is.
And just for the board and the neighbors' edification, is that plan that's shown up on the computer?
It is.
Okay. Can you please walk the board through this plan? Can you explain
Sure.
where the lots will be, the lot lines as they exist today, and where they will exist as proposed?
Yes. The lines that are shown as a red dashed line are the current existing parcel lines. 2 parcels to the north, 2 parcels to the south. The green thicker line is the proposed lot line adjustment, and we will be eliminating the internal lot lines here, as well as the internal lot line dividing the 2 southern parcels, which would result in 1 larger consolidated northern parcel, as I'm outlining, and 1 larger consolidated southern parcel, as I'm outlining.
Can you show the board what portion of the southern parcel will be rezoned from general industrial to light industrial?
This portion here would be downzoned from general industrial to light industrial.
Can I ask you a question? Can we do it on the map there so that I can see what's going on? and-
Sure.
That's
I
right.
didn't
Yeah,
see
I didn't realize that.
Yeah.
So let me back up a second. The red lines, the red dashed lines, are the lot lines as they exist today. We have a parcel to the north here, parcel to the north here, parcel to the south here, and a parcel to the south here. The newly proposed consolidated parcel to the north is made up of the thicker green line as well as the thicker gold or yellow line, if you will. And the consolidated parcel to the south is made up of the thicker gold and green lines in this area.
And which portion
Hang on one second. Are you here for this case?
Yeah.
So maybe you should do it on this side so they can
Okay.
see it. So one or the other, somebody's not seeing it. I
Yeah.
think the residents should be able to see it, so.
Well, he did that already. They saw. You did that one already. so-
Yes.
But if you're gonna do it here. so
Do it both,
the
yeah.
residents
Okay.
can see it, right?
Just so we get back on track and so
Yeah.
everyone understands, can you point out very quickly which part of the southern parcel we're proposing to be rezoned?
This would be the portion that would be downzoned from general industrial to light industrial.
And that's the front portion of the southern T?
Correct.
Okay.
Front portion of what?
Of the southern lot, the southern portion.
Current southern lot.
Of the southern lot.
You propose southern
Yeah.
And, yeah,
It's the same thing.
yeah, do you
Sure.
want to show where Galloway Road is, just to make everyone understand what part's being rezoned?
Galloway Road
The
would
front
be
of the southern
located
lot.
in this area here.
Here, and I'll try and do the,
Yeah, on the other side. Yeah, something
Yes.
like that.
so the portion that's being rezoned is where I'm moving the cursor over what would be the southwestern portion of the lot.
Correct.
Okay. And can you just briefly explain to the board why this consolidation makes sense?
As the lots currently exist, essentially, we have what could be a landlocked portion, which would be the eastern side of the southern two parcels, which in theory, that parcel could be sold and not have access to Galloway Road. So for consistency, the lots are being consolidated to provide access.
In addition, will combining the lots reduce the number of uses to which these lots could be used?
Yes,
So right now, you have 4 separate lots. Under zoning, every lot can be used for a different purpose. Once the parcels are combined, there could be one use on the southern lot and one use on the northern lot, correct?
correct.
In your opinion, will the proposed rezoning have any adverse impact on the surrounding community?
No.
And is this due to the fact that the rezoning request is actually to allow for a less intense district, that is the light industrial district, rather than general industrial district?
Yes, the proposed zoning would be a more restrictive zone use than currently exists.
Okay. And everyone can see up on the plan, regardless which section you're looking at, there's purple, there's lots of pretty purple on the plan. Do you see that, Don?
Yes.
Can you just explain to everyone what that purple is?
So the purple areas are environmentally sensitive areas, consisting of wetlands, streams, and the associated buffers that are required by the township around the environmentally sensitive areas.
So do those environmentally sensitive areas, like the existing wetlands, also provide essentially additional protection for the neighboring residences in that you can't build in those areas?
Yes.
We discussed that the light industrial is more restrictive than the general industrial. Can you provide any examples of this more restrictive nature?
Light industrial, there are uses such as sales, office space, as opposed to the general industrial, which would allow for different types of manufacturing, perfume manufacturing, paper manufacturing, things of that nature.
So just to summarize, if the proposed rezoning is granted, any development on the south, really southern entire portion of the property, but particularly the southwestern, would be more limited than currently is?
Correct, yes.
Would there be any other benefits to the downzoning? For example, would the maximum building height be decreased?
Yes, maximum building height
Yeah,
would
we're
be
not giving any rights
decreased,
to
and
it.
lot coverage would also be decreased. So there would be less development allowed on the lot area.
So in addition to these reductions, are there any other protections in place to protect adjacent residences?
As we mentioned previously, I think the biggest protection for the adjoining property owners are the environmentally sensitive areas and the associated buffers and restrictions with those. As you can see, there's a fair amount of environmentally sensitive areas on the southern parcel, particularly adjacent to the property lines. So any development that may be considered in the future, either by Foley Cat or a potential buyer, would be restricted to the non-shaded areas.
And are there also buffering protections required by township ordinances, setback protections next to residential districts, landscaping requirements, and a township noise ordinance in place?
Yes. So the creek is in this area here. And also, I believe a portion of it runs along here as well.
It goes back to Galloway too.
Okay.
It goes back to
Well, again, the environmentally sensitive areas that we're showing in purple are either wetlands or water courses. So essentially in the purple shaded area would be the creek.
I can walk to the creek, about 30 feet behind my property, and I don't see the creek.
Well, we're not showing the creek on this plan. If you guys have the lot consolidation plan in front of you, it is shown on there, along with the required buffers.
Is this plan merely to show the amount of environmentally sensitive areas and what portions can be developed, just to aid in our answers of questions of the residents? Is that correct?
Yes.
Well, the creek is environmental, also.
Correct, with the associated buffers,
Where
yes.
is it? Is it in the big maps, you said?
You want a big map, sir?
Where does that show the creek?
If you have one handy, I could come up and show you.
Yeah, I don't know that, we're happy to show you, happy to answer your question. I don't know that the exact location of the creek is,
Well, if the mayor wants to say, he can check it
Yeah,
out. But
absolutely,
here's the thing, though. Just to clarify for the audience and for
Yeah.
us, the fact that you get this, if you get this subdivision and you get this change to light industrial, which is actually a better zoning for the surrounding areas, it doesn't give you any extra rights to build in the buffer
Oh.
or build near a creek or build in the wetlands.
no,
Okay,
absolutely
I
not.
just want to clarify that.
No,
So-
absolutely not. And in fact, any land development, as the township council is
You'd have to come in
aware,
and-
we have to come in and present plans.
And you'd have to respect the buffers. and
Absolutely,
require-
yeah,
Okay.
that's,
Okay.
Yes, this is a portion of the one creek here. This is a portion of the other here.
It's a two-story.
Doesn't that continue from here?
Yes, that's this line, this dash line right here.
And where does it end here?
Comes up here, runs along here. There's another branch that goes over this way, down that way.
Okay.
Up this way.
Okay.
Okay?
Yeah.
Thank you.
Don, just so the neighbors can also see, can you just, with your pointer, show on the map? I want them to just understand for bearings, getting their bearings, where the creek is that you just showed them there.
The creek runs down this way. There's a tributary that goes down here, comes up, down through here, and also extends up along the property line this way.
Okay.
And just to reiterate what Mr. Knowles asked me and I stated, it is correct that the application tonight, there is nothing on it that eliminates any requirements we comply with setbacks, allows us to develop in the floodplain, or for that matter, allows us to do any land development. Is that correct?
That is correct.
Okay. In your opinion, will the proposed rezoning have a minimal impact on adjacent land uses?
Yes.
And in your opinion, is the requested rezoning a reasonable request?
Yes, it is.
And is this reasonable so that the property will not be split zoned?
Yes.
And it actually downzones the permitted uses, correct?
Correct.
In your opinion, is the requested lot consolidation, lot line adjustment also reasonable?
Yes.
Okay. I have nothing more for Mr. Barra, but he will remain available.
Okay, that's
for
fine. He
questions.
was very thorough.
Okay.
That's all right.
I have a couple of questions, actually.
Okay. Why don't you let him testify, and then we'll go have questions.
Well, I think it was pertaining to what he was
We'll
discussing.
both be available. Let him get done.
All right. Can you please state your name for the record?
Ken Fleck.
And what is your affiliation with the applicant?
I'm the Director of EHS Facilities for Foley Incorporated.
And is the applicant the owner of the properties here?
Yes,
On behalf of the applicant, did you also post the subject property about this hearing?
yes,
And if the board turns to Exhibit A7, is that a true and correct photo of the posting of the property?
yes.
And when did you post the property?
January 18th, more than a week before this
And is the
hearing.
posting still there?
Yes.
And when were the properties acquired by Full Pen?
January 12th of 2023.
And just to reiterate, is Full Pen a special purpose entity that's affiliated with Foley?
Yes.
What is the use on the two northern parcels?
It is a Caterpillar facility, sales and service facility.
And what's located on the southern parcels?
It's vacant.
And what relief are you seeking today?
A lot line adjustment, a lot consolidation, and rezoning to avoid split line. split zone.
And does Foley intend to continue using the northern parcel as it's used today?
Yes.
Is there any land development planned on the southern parcel whatsoever?
No.
What does Foley intend to do with the southern parcel?
Marketed for sale.
Okay. Has Foley started this process?
No.
Does Foley have any potential purchaser in mind?
No.
Why are you seeking the rezoning of a portion of the southern parcel?
To avoid a split zone as requested by Township.
And what zoning districts are these 4 properties currently subject to?
General industrial and light industrial.
Okay.
Like,
Light industrial.
If the proposed relief is granted, would the consolidated property, the southern portion that is, be located within the light industrial district in its entirety?
Yes.
So you're effectively seeking to downzone the general industrial zone property,
Yes.
at least the southern portion of it. Does Foley understand that if it seeks to do any more development on the northern parcel, it would need to come back before this board and submit a plan that complies with setbacks, environmental matters, floodplains,
Absolutely, yes.
and that this board would have the ability per law to review it, give comment, have their engineers review it, and go through the entire process?
Yes.
And if Foley Cat were to decide to retain the southern parcel, does it understand that it would have to come back and go through that process and adhere to law or get variances, whatever, with regard to the southern parcel?
Yes.
And tonight, we are not seeking to get around those rights, for lack of a better term whatsoever.
No.
Okay. I have nothing further for this.
okay, so they can say, Ms. Neat, you have a question
Yep.
for her?
Yes, and in putting the 2 parcels together as one, would that not allow you a higher percentage impervious surface? Not percentage impervious surface, but really what you're doing is you're making it a lot bigger so that you're able to have more acreage. And I understand your process of sale and the reason behind the zoning change and coordinating that effort, but if we're making it one parcel, you would then have more acreage, thereby giving you a larger building to build.
Are we referring to the southern?
The southern, yes, exactly.
For the southern portion,
Right,
it-
based on impervious.
well, there's no improvement on the parcel right now, so there is no impervious coverage existing, so I'm not quite sure I understand the question.
Because when the future, you're going to sell the property, somebody's going to want to build on the property. They're going to be able to build a bigger building because they have a bigger lot.
Can I ask a follow-up question that might help sort of illustrate this? Don, I think what she's saying is, let's say each parcel is 25 acres. Or each parcel is 10 acres in the southern portion. 55% of 20 is different than 55% of 10. But if we didn't, is that correct?
That is correct,
Okay.
yes.
If
You-
we,
go ahead.
if we didn't change this lot line though, couldn't we have 55% of 10 on one and a different use with 55% conceivably?
Not
On
on
the
this,
other.
not on this property based on what you're showing me with wetlands.
Well, that was going to be a
Right.
follow-up response maybe that I had. You can't really use the 55%, well, you can, but it's 55% of
The net.
developable area, yes. So it would be 55% of the areas for development, which I think if we did the calculations, it would,
And woodlands. Sorry.
it
We were
would,
clarifying.
it would be less, you know.
Well-
The consolidation, if we're looking at it merely lot by lot, as we're looking at it right now, you know, essentially, the lot to the west, this lot here, or this lot here, as we're looking at it right now, you would be 55% of this area. You're not going to do anything down here. You're not going to get across the wetlands, so just take that right out of the equation. So I think the short answer to your question is yes, but again, we're not trying to get around anything. There's no development proposed. The main purpose is that, in theory, this lot could be sold with no access. There's no road frontage for this lot currently, so to make the parcel more marketable, our client decided to consolidate the two lots.
And I have another question. I saw in letters from May of 2024, we noted, Phil, this might be a question for you. We noted the max building could not exceed 25 and 55% respectively. But then in September 2024, we increased that to 35 and 65% respectively for the, give me one second, I'm sorry, I have it right here, for the maximum building area. So what was the change between May and September? Can you remind me why we increased the maximum building area between May and September on the plan?
I'm having a hard time following why we're even talking about building coverages at this point, because
Well, I
it
understand
really
that at its
has.
surface on the agenda tonight, we're talking about zoning and
Sure.
we're moving parcel, moving lines.
Right.
It's as simple as that, yes. But I'm here for the long term, I hope.
Sure, and this
I'm
was-
questioning what the future development of this property is going to look like. You're going to sell it. Somebody isn't going to make it a park.
Right.
So
I
when
mean, they'll
they're
be
giving them
limited
this,
by the
they're going to have
environmental.
additional,
Sure.
they're going to have additional, I guess, an advantage to building something bigger based on the total parcel increase. Yes, on purpose. You answered my question. Thank you.
Okay, and not that,
I'm just pointing it out.
I understand, but also we did request they make both of them the same and make it light industrial, because if you had one that was heavy industrial, one that's light industrial, and then someone comes in and wants to build on one and then says, oh, it's not fair, I have split zoning, I'm going to court over this, or blah, blah, blah. So we wanted light industrial, that's what we do. Okay, so Mr. Kisselbeck has a question.
I do. It's Ms. Cobalt, do I have that correct?
Yes.
All right, did you say the owner is here or is not here?
Yes.
Yes.
I'm representing you.
You're representing the owner.
Yes.
You're not the owner, however.
I'm not the owner, I
But-
work for.
Okay, that's fine. I just wanted to know where we are. Okay, I'm going to make a proposal to you. I think it makes sense for us, and it makes sense for you. I think you should take the bottom portion of that, instead of going with light industrial, you should make it institutional, you should donate it to the township. Well, don't laugh there, sitting there and making faces at me, because there are things called tax write-offs that the owner could benefit, and as far as somebody buying that property, you had just admitted the only aspect of that property you could use as 14 acres would possibly be 5 acres, and trying to get back there is going to be a major problem anyway, and I think if it were donated to the township for the assessed value of the property, you would have that major tax write-off that you could take a benefit of that, and donating to the township would be appreciated.
I am obligated to present that to the ownership of Foley, since you have suggested it this evening. That's not what we're here for. I don't think approving what we're here for would foreclose that possibility, and I will certainly present that.
And what you're saying is absolutely correct, and that's how I would expect you to present it, that this is something they
I-
should consider and
I
look
am
at
obligated
it,
to
and
do so, and
possibly
I will
put that out. If they want to sell it, see what the market value is, have it appraised, they do that, and I think that would be quite beneficial to your company, Cat Foley, in terms of either tax benefits or financially being certainly beneficial to everyone.
And I've done that with other townships or other clients, so I will talk to my client
Thank you very
about
much,
it.
okay.
Okay, is there anybody else, any other council who have any questions for the attorney or any or two experts, the owner, representative, and the engineer? You have a question?
I do, it's actually just, so the house is on the new southern lot. That is all Hidden Valley, if I'm not mistaken? Chancellor Glen, is that close to the Turnpike, or are they all Chancellor Glen? On both lots?
Northeast.
So Lot
Along the
1
turnpike.
and Lot 2, the new Lot 2, all of it is Chancellor's Glen.
Chancellor's, is this Chancellor's Glen, Ken?
Yes.
Okay, what about that, then next, nope.
Behind this southern.
I know who they are.
Right there, right there.
Yeah, right in there. Is that Chancellor's Glen too?
No.
The upper right-hand, so that's Hidden Valley.
That could be back.
That's Hidden Valley. Okay, that was my question, that's what I thought. Thank you.
And the mayor's house is there.
Yeah.
You know how to say that.
We knew where his house was.
Okay, is there any other questions from the board? If not, is there anybody that would like to come up with any comments in reference to what we're, make comments about anything about this, but in reference particularly of what we're considering doing this evening? If you come up and get in line, introduce yourself. Go ahead, ma'am, come on up. Okay. Well, if someone wants to come up and maybe, well, you can't speak from the floor, unfortunately. I don't think we can come up here. We can take a microphone over, maybe.
Len Zimmerman, I'm 126 Liberty Drive.
Okay.
And
Spell your name for me, please.
last, Zimmerman, E-R-M-A-N. E-R-M-A-N.
One N is it. And it's Len first.
Len, as in the lender.
I'm sorry.
It's okay. So I have like two questions, actually. The north parcel, is that zoned general industrial now?
Yes.
And how about the parcel behind it, right behind our property?
That's a good question. Is the back of the north also general right now?
Are we talking this parcel right
Yes.
here?
Yes.
Yes, that has always been general industrial.
Yes,
And that's going to stay general industrial?
yeah.
Okay, so the floodplain there, that's right behind my property, what prevents them from building behind that on my side?
Lots.
Well, they have setbacks, and they have setbacks
The
off,
setback, I believe, is 50 feet? Is that
no, but
correct?
setbacks off the back, and setbacks off the wetlands, off the purple and off the back. So to fit something in there that would be feasible would probably be
Yeah.
hard to do.
Any development, this is the floodplain here.
Yes, right.
There's ordinances within the township that restrict development within the floodplain. So the natural characteristics of the floodplain area would highly make any development in this area very, very, very highly unlikely.
Okay.
And could you clarify that, because you clarified that there's no immediate plan for the southern part, but there's no immediate plan for your company to go back right away and build something on the back lot, right?
Yeah, I can answer that. I just want to, in full candor.
Yeah.
There is a plan that is going through PennDOT. It is not for new development. It is because the previous owner decided to do some, not PennDOT, I'm sorry, Pennsylvania Department of Environmental Protection. The prior owner decided to add some gravel to the site that township did not approve. So the township requested we show that, go through the development process on that. And we're doing that at the township's request to cross the T's and dot some I's. That's not yet before you, but it's going through the process.
There's no plant structures
It's
on the
not-
back?
No,
or
it's not.
No
It's-
garages, no
it's-
trucking?
It's crossing T's and dotting I's that exist
Okay,
today.
all right, okay.
So that parcel can't be developed. What are the chances that that could be changed from a floodplain by, like I seen what they did to the parking lot over by Home Depot, where they tore the whole parking lot up when they built Audi. They put a whole system underneath that for drainage with about a 4-foot pipe that run into the retention basin so that they could divert the water. Is that possible?
Well, that was the stormwater management.
I think
Okay,
Phil
yeah.
should be,
Yeah,
Mr. Morse
Phil,
can answer all that.
They
related
can't
to-
remove wetlands in the back and build on top of them? No.
Right, okay, that's
No.
really all the question I had. So I'm good.
Okay, thank you. I mean, if you want to have a question, if you want to yell out, and I'll try to pass on.
Shut down, that he's referring to the wetlands, and they say that they can't be used.
Right,
Now, I'm 127 Liberty Drive.
Right.
And I'm right behind this property.
Right.
And the wetlands are there.
right.
And, you know, the attorney said it's unused land. It's not only unused, but it's unkept. So there's trees back there that have died. In past storms, we've had trees fall over 2 years ago. This is before they owned the property. Josh Ransom had it, and trees came down. Josh Ransom offered $500, and the cleanup was $3,500. My neighbors and I put the other $1,500 each to get it cleaned up. There's still trees that are dying and leaning over towards our properties. So,
Okay.
whose responsibility is it the township?
Okay, what's your name, ma'am, just for identification?
March is first name, and last name is Sadov, S-A-D-O-F-F.
And you're at 127 Liberty?
127.
Okay, well, we can look into that, and there's a responsibility, and we'll see whether we can force them to clean up the back. Yeah, so, right, okay?
My client will also look into that and take a look at it.
Okay, we'll address that, we'll get the back cleaned up for you, okay? All right. Okay, is there any other questions, or anybody else that would like to come up and make a, again, not that I'm like we felt before that leaving it general industrial would be worse, and then it would also put us in a position where they went to court and said, oh, look at what you made us do, and now I want to put this factory in here or this thing in here, and half of this is light industrial. This way, it restricts them, that it has to be a light industrial use, and it has to respect the wetlands, it has to respect all the setbacks. So if they do build something in there, it's going to be very limited what they'll be able to do and what they'll be able to use it for.
Or it could be a wonderful.
Or there could be a park, yeah. It could be a park if they so.
Where I will discuss that.
It'll be at least discussed, okay? Okay, so seeing no one else come forward, we'll close public comment. Is there any other questions for the board? Okay, if not, Joe, we have to do these separate, right? Do you have any points to make?
Well, there's two different scenarios that need county law wide for the cover. And we have two different zones, but one's from Black sometime a year ago.
Okay.
And then we have a middle one. We'll make sure to take care of that. Second thing.
So that's an answer to Ms. Benitez's
Yes.
question, okay?
And I do have one comment with regard to access
Okay,
that I think should be addressed with regard to if there's any conditional approval of some sort. And that is, the bottom of the parcel really has no access to the road.
right, back,
And even if it does, no, even out to Galloway Road.
okay,
So even the creek and also the area in that location is at the bottom of a hill.
yeah.
So your site distance is very limited. So I think the applicant should do something. I wrote something down to basically say that we recommend that the applicant, I don't know how you're voting or not, agree to provide access easements for future connection at the direction of the town, with the direction of the, and guidance of the township engineer. So that would mean that they might have to take any type of cars or anything else up to their main driveway that it is now instead of back at the bottom of the hill. So I know it's not normal with this as part of a.
Now, is that something that we could force them to do if they ever came in for something?
Well, that parcel's going to have its own rights of access.
Right.
And if there's only one access point, and that is out to Galloway Road, it's going to be a right in, right out, probably right in, right out driveway.
Right,
And if that's the case, people that are going to that parcel are going to find their way around and have to turn around or come a different way, maybe from the middle of town.
okay, so what do you
No, I
propose
think
now?
that they have to have some sort of easement or shared access at the main driveway if necessary for the bottom parcel.
And I don't think Foley would be opposed to doing that. In fact, I know they wouldn't be opposed to doing that, but without a plan for the southern parcel, I don't know what that would look like, and I don't want to say, oh yeah, we'll definitely do that, when, if it's a, 10,000 square foot MOB.
You have to, so,
Yeah.
correct me if I'm wrong, but you're saying they might have to allow, if something on the southern border is proposed, they might have to allow an easement through their property on the northern part to get in and out, to get to the back.
That's what I would like them to commit to
Right.
allow that access, because otherwise, if they sell it to someone that may not be friendly, they're entitled to an access out to Galloway Road.
Okay.
And they would have to do something with the wetlands, replace them, do something.
Right, or put a bridge or something. I don't know.
Something
Yeah.
they'd have to do. So
Okay.
instead of doing, plus they would still need a right in, right out access point. And that would be a bad
Is
thing.
Galloway Road something that they would have to deal with PennDOT too?
Yeah.
On
They
the
would.
entrance and exit?
They would.
And that's candidly why, well, we're not opposed to it in concept. It's really hard for me to, stand here tonight and say, yes, 100% we'll connect to this drive or that drive. PennDOT may want us to do something different than that. I don't know at this point. And that's why I'm not opposed to talking about it, based on what plans are brought for you when the southern parcel is developed, or candidly, when, there's true land development on the northern parcel, we revisit it. I'm definitely not foreclosing on it, but I do think it's premature tonight with the applications that are pending before the council to
Okay, but
say
it's-
yes or no.
But it's at least on the record that you know that that's a possibility you're
It
going
is,
to have to
it
do.
is on record that
PennDOT may force you to only have one entrance there, and there may be
Yep.
one way to do it.
Yeah, because we don't get to develop the property ever, no one does without an HOP. We understand that, absolutely.
To Mr. Worst's point,
Go ahead.
part of the, if I'm looking at that plan correctly, part of the lot line change that you're asking council to approve includes pulling the property line that's dividing what will be the future northern parcel from the future southern parcel, pulling that property line south
Yep.
into the southern parcel,
Yes.
and likely restricting, or further restricting, as the case
Yeah.
may be, where the access point into Galloway Road
And-
would be absent,
It kind of dips right after the end.
absent some sort of easement agreement. It would, if an easement agreement like that isn't in place, then perhaps following the existing dividing line between north and south makes more sense.
Here's,
if that becomes a question of access. So it may behoove you to agree to the concept that some sort of a note be added onto the plan that's going to be recorded to reflect this lot line change, that an easement solely for access to the southern property from Galloway Road will be provided to the southern property at a location to be determined in the future. But it's at least memorialized that that access easement will be provided at that time.
and as permitted by PennDOT and approved by PennDOT.
Well, certainly.
The reason, I'm sorry, the reason for the dip down is so that the property lines coincide with the zoning district, so that we don't have, and this gets us around the concern that you had back in May about having a lot that is partially in one district and partially in the other. Right now, you have that.
Right, well, and I don't know that putting it back where it was
Yeah.
is actually going to give you an easement.
Yeah,
But
it doesn't.
I think you should agree to provide an easement per PennDOT's approval, or otherwise, we're going to be battling with somebody else, and you're going to be selling a property that they can't get to anyway.
Mr. Pizzo was more eloquent than I was.
I noticed that.
Yeah.
But clearly.
We took note of that, by the way.
But clearly, you could put the easement in, and if it's not needed, you don't need it. But if you have it, if you need it, you have it.
Yeah.
Otherwise, we're going to be the ones paying the
Battling with
price for
somebody else,
something
right,
out on
right,
Galloway
right,
Road.
right. Somebody's going to be suing us.
If we approve this the way it is, we're approving a landlocked piece of
No.
property.
Close.
Well, without the easement.
Close enough,
Yeah,
without
yeah,
the
yeah,
easement.
Well,
yeah.
So what
yeah.
I'm saying is, we're
You
going to approve something that doesn't have an entrance and exit, that can be a problem down the
You
road,
actually
so why
already
would we do
have
that?
something that doesn't have an entrance in
But
it.
I'm saying, why we approve this tonight?
Right,
if
but you'd
there's
have to
not?
go over, right
We-
now, you'd have to go over wetlands somehow,
Yeah, we-
and we don't want you to do that.
The proposed lot meets all of the township requirements for road frontage, minimum lot width. It's a compliant lot per township ordinance. And the county also reviewed this plan prior to it coming to municipality, so it is a conforming lot.
I know, but if you're saying, okay, that you cannot disturb the wetland area that's in purple.
I'm not saying
Okay,
that, per township
per
ordinance.
township ordinance, okay? And you're already agreeing to that, okay, so there's no way to get a driveway from the front of that property back to the back of the property without going over the wetland. So we're asking if you want to put an easement in, or at least agree that you would put an easement in, if PennDOT agrees to it and it's necessary for
I think-
access to the lot.
What I can say is we will agree to the plan note with language acceptable to the solicitor in the same regard that we've been discussing, and that is an easement subject to the approval of the township at the time the southern lot is developed and subject to PennDOT's approval.
Perfect, right, Joe? Is
Yeah,
that good?
that'll go on the plan as a note.
And the solicitor and I can work on language to that effect to add to the plan before
Okay,
it's signed and
we'll put it part of
recorded.
our motion.
Okay.
Okay? Or someone will.
Okay.
Okay,
I got it.
okay, so, it's good. Okay, Phil, thanks for bringing that up, by the way, thank you.
Hey, that's
Okay.
why he's here.
Yes, why you're here. And Paizo, that's why he's here.
It's another preface.
Okay, okay, so the first one would be dealing with the zoning change from general industrial to light industrial for the entire lot, which we're describing as the southern lot. Okay, so the front and back lot on the southern part would be one zoning to light industrial. Do we have a motion to approve that?
I'll put in the form of motion that agenda item number 6, consideration of a rezoning is approved according to the application that's in front of us today.
Okay, is there a second?
Tax map parcel 02-033-066-004, and as you had said, Mr. Knowles, it's a general industrial and a light industrial classification.
Yeah, it would now become light industrial, the whole thing, changing both of them to light industrial.
No, one stay in general. Oh, the bottom.
No, both of them are light industrial now.
The
Okay, so
second
there's a rezoning for light industrial from general industrial to half now is general industrial. The whole southern tier will be light industrial, okay? So that's the motion on the tax parcel that Mr. Kisselback put in his motion. Is there a second on that motion to change the whole thing to light industrial to southern tier?
I'll second that.
Okay, all in favor?
Aye.
Aye, any against? Okay, that's it. Okay, so that's done. All right, so we're
I'll take number 7
5-0.
also.
Okay, number 7, is there a motion for number 7 to adjust the lot line changes as discussed in the motion?
Okay,
Can I ask Mr.
Sure, Penny, yeah, absolutely.
Mr. Pizzo one
Please
question?
do.
Because he did, the gentleman there, Mr. Pizzo. So with the wording that you all decide to do, for the easement, in essence, someone in the future who may purchase this lot may say, well, you have to let me do this here to go over the wetlands and the creek and everything because you've created a non-conforming lot with no accessible point. All the
Well, we're not,
regulations.
because we're saying
Because
that
the
they could get an
easement, I
easement.
just want to be sure
Right.
that we
Yes.
have that on
Yeah.
record, that that's our,
Yes.
part of our intention
That's
of
going to be part of
doing
Mr.
it.
Kisselback's
And
movie.
it has to be a plan note, and that plan gets recorded. So any subsequent owners of either the northern or southern partial
Would have to agree to that.
well, and they'd have constructive notice of it as a recorded document with Bucks County.
I just don't want somebody to come in and say, have to let me do it, I have to destroy that because I have no other way to get there.
Yeah,
That's my concern.
that's, we take care of it. Okay.
Language to the effect that an easement for ingress and egress from Galloway Road to the newly created southern lot shall be provided over the newly created northern lot at the time of land development of the southern lot. Such easement to be located as determined by the township, the Pennsylvania Department of Transportation, and the applicant at the time of land development application for the southern lot.
Okay, we can add that to number 7. the
Well, I'll
second.
go with that as.
I'm not saying that has to be the language.
No, that sounds
So we can
perfect.
add the second
Pretty
number
close,
7,
but
right?
it sounds
With
a
lot
lot, it's a
combination.
lot better than what I would have worded
Okay.
myself and or Phil, of course.
Okay, so is that part of your motion, Mr. Kisselback?
Phil? You agree? Oh, I'm sorry. I didn't look up. No, that's okay. No. You were right on. Okay, what Mr. Pye said was relative to the easement, and he put it in legalese terms, so it's perfect. And in addition to that, then we agree to the lot line change as presented to us this evening, and with the caveat, as Mr. Pye has worded, that there will be an easement approved by council and PennDOT and any other legal entities that would be concerned with that.
Okay, so there's a motion on the floor. Is there a second on number 7 with Mr. Pizzo's amendment for an easement?
I'll make a second.
Okay, all in favor?
Aye.
Aye. Any against? Okay, so we're good. You work it out with Mr. Pizzo, and we should be good, okay?
Thank you.
No, I don't really want them back.
You should have made part of the motion.
What's that? There was public, that's these, what's that? No, we did 6 and 7 together. So 6 and 7 was together, yeah. Well, we did 6 and 7 together and discussed it before we started, and Mr. Pye pointed it out to everybody that we're doing 6 and 7 together. There was no public. Yes, yep. We're good. Thank you.
Thank you.
Okay,
Go Birds.
okay. All right. Let's make it even for Eagles to get onto the property. Okay, so is there, number 8 on the agenda is consideration of preliminary and final land development for Penn J Petroleum LLC, care of Shanu? Is that how you say your name? Shandu? Sandu. About to toss here, huh? Okay, this is preliminary final land development. Mr. Pazzo, do we need to have notices out here? Did you get notices?
Notices have been handed to me, Mr. Knowles. I'm reviewing them as we speak.
Okay. And then we'll assume that that's going to be okay, okay? And one clarification I wanted to make right off the bat, because a couple of people mentioned, we did go to a 2-story building.
That is correct.
And the engineering comments indicate that it is a 2-story building, so you'll adjust the drawings that were submitted that had it 3 stories on, mentioned.
That's right. It's a 2-story building. We'll affirm that for the record. It can be listed as a condition of approval, but it is a 2-story building.
Okay, all right, thank
Yes.
you.
All right. Good evening. Mike McGinnis here tonight on behalf of Penn J Petroleum, the owner of 2720 Knights Road, the township. The subject property is located in the GC district. It is just under half an acre, it's 0.43 acres in total. And we are here to discuss, as Mr. Knowles just mentioned, the construction of an office building on site. The office building that we're proposing is just under 3,000 feet of gross leasable area. It is a two-story building. The second floor of the building, which is approximately 1,575 square feet, is intended to be owner-occupied. Our outlook with that is right now approximately 2 employees. And then the first floor will have approximately 1,375 square feet. This project has been in the pipeline for a number of years. I believe Dr. Sandhu originally had conversations with our office probably back in 2020. We submitted a version, an original application that was before the township in 2021. So it's something that we've been attempting to get accomplished for about 5 years. We're excited to hopefully bring this to a conclusion and fruition tonight. This property has historically had a number of issues. We discussed this with the Planning Commission when we appeared a couple months ago. Dr. Sandhu, not himself, I want to reiterate this, not his issue, but there have been some impermissible truck parking to the Plan East version of the site. There was dumping that had occurred over the years. And we're excited to move past that and in its place build a new aesthetically pleasing positive use in the form of this new office building that we're seeking approval from council this evening to construct. There is, as I noted and as you can suspect, based upon the limited number of employees, almost no traffic impact. As you can see, and we'll discuss, I know this is always a concern of council, but in the WK2 review letter, you will notice that there is a large stormwater management improvement on the site based upon the stormwater controls that we are installing versus the existing conditions. The letters, both the traffic and the civil engineering review letters, are fairly limited in terms of their outstanding comments. I will make the representation at the outset that everything in both of those letters are will complies, with the exception of a couple waiver requests, which we will detail in a second. I have Doug Waite from Jones Engineering. Just do a little bit of an overview for your consideration of what we're proposing. Dr. Sandhu is here with me, can give additional detail regarding his interest in moving forward with construction. And then if it works for council, we'll pivot to the review letters and the waiver requests that we're seeking.
Okay.
So, thank you.
Doug Waite with Jones Engineering. The existing lot is a, let's see if I... So the existing lot, there's 2 lots existing. Adjoining the subject lot is a gas station owned by Penn State Petroleum as well. Currently, the lot is almost completely covered with pavement and gravel. So the I could use this instead.
Yeah, probably.
Since there's hardly any. So the majority of the lot is covered with existing paving for the 2 lots, excuse me. It's covered with paving for the gas station, and this lot is covered with gravel. There's some steeper slopes and vegetation.
Okay,
in the back.
can you speak into the speaker?
So the subject lot is gravel covered with vegetation towards the rear. So the proposed condition is to take away or remove a good portion of the gravel and improve the impervious condition of the lot by introducing landscaped areas either side of our proposed parking lot, which is 15 parking spaces with a traction enclosure in the rear. There's a separate access to the lot proposed off of Byberry Road, and with sidewalks that will access the building and tie to the sidewalks along the adjoining lot. The proposed building shown here is just under 2,000 square feet of footprint, and will include proposed utilities, water and gas tying to existing services that run along Byberry Road.
It's Knights Road, I think. I think it's
Yes,
Knights
it's
Road.
Knights Road.
Yeah.
And the sanitary sewer will tie into an existing sewer line that runs behind the gas station to the rear of the lot.
Okay, and there's stormwater in here, so you're saying that you're going to improve the stormwater situation?
Correct. The existing condition, a majority of the lot flows, there's a slight high point just inside the roadway. And a large portion of the runoff goes towards the rear of the property. With the grading for the existing, the proposed, with the impervious coverage of the building, the drainage needs to be picked up towards the rear of the site here with an inlet, and the drainage will then be held and controlled by an underground stormwater retention basin and tie into an existing inlet within the roadway. So the overall effect of stormwater management will greatly decrease the runoff towards the Pleasant Creek, which runs behind the properties over here off of Ontario Road. So we're in the process of a PennDOT permit, working on obtaining that permit.
Okay, it'll be conditioned on the PennDOT approving your entrance?
Absolutely,
Yeah.
yes.
Okay, is that it, Mr. McGinnis, for the?
Yeah, I think the scope of the
I'm going
project.
to ask you a question.
Sure.
Go over this letter dated January 21st, 2025.
Is that the traffic or the civil?
Engineering Consultants, WK2, is that the proper name of your? Squared, is it squared or two? Two. Okay, okay, just squared. Okay, my question will be under zoning ordinance comments. You said, okay, first of all, you understand that there is an impact fee that you're agreed to pay, the impact fee that's determined?
Correct.
Okay, and then I was a little concerned about this first one. It says steep slope overlay. Is that something that you were able to handle, or what's the deal with that?
Yes, so the note from Ms. Khan is that we provide the computations and limits, and we've demonstrated compliance with the ordinance.
Okay, so that was taken care of?
Correct.
Okay. And then the second one on the next page, page 204, says that you were reduced to 2 floors and you'll make the proper adjustments in the
That's
paperwork.
correct, yes.
Okay, so that was done. Now, the fire lanes, were they, number 3, was that adequately?
Yes, we received
addressed?
approval from the fire marshal.
Okay, so everything he said about the fire marshal. And then the off-street parking concerns A, B, and C, were they addressed?
They've all been addressed, that's right.
Okay, and they're will comply at this point?
Yes, I think we have complied with those.
Okay, good. Okay, and then under subdivision and land development at the bottom, there's just comments, basically. But is there anything here that you're asking for a waiver?
Yeah, so our waiver request, the comment under the preliminary plan requirements, 241 is will comply. The waiver request that we're seeking, if we go to page 3 of 4, at 201, 106, there are actually 2 waiver requests, although they're split in A and B in the letter.
Okay.
The first waiver request relates to the street tree planning, and we discussed with Planning Commission, it's noted in the Bucks County Planning Commission review. The reason we're asking for that waiver relates to the existence of overhead lines that would preclude the planting of trees in that area.
Okay, and then you'll make a donation to our tree bank for the...
A fee in lieu of whatever the tree requirement is, that's correct.
Okay, and then I do see now that there is another one below. Can you explain the applicant's requesting a waiver? Grades must high and closer than 3 feet. This office supports the request. What's that?
Yeah, and Doug can point out where this is, but due to some of the unique site constraints here, we have grading that is within 3 feet of the property line. If you can highlight.
Yeah, I'm pointing towards the rear of the, still on the west side plan view, and also along where the driveway tie-in is.
Right. So this is a waiver that we tend to ask with a few different applications.
Yeah, I thought...
In this case, it's even more, I think, easily justified because our client controlled neighboring property, so we're certainly not going to object.
So you agree with that, right? That's normal.
I have one question. Is that a picture or?
Yes.
Of could we see that in
Sure.
terms
Yeah,
of?
replica, yeah.
Some of the,
Yeah, actually,
I think we have
I
a
have it on
digital.
the,
It's a good idea.
well, yeah, just because we're talking about like.
Sure.
Yeah,
Well,
we can
we
bring
can't
that out a
see
little
back
bit,
there.
Phil. We can't see.
I can't see behind Mr.
It's put
McGinnis.
behind its back, so
We're going to put it on the screen.
you can put it up here, maybe. Okay, that's good, yeah.
Thank you.
You're welcome.
Okay, so that's 2 stories,
That's the
right?
2-floor building.
Okay, 2-story building. Okay, and then what's the deal on the sidewalks?
Sidewalks will comply, so that's just a plan note, labels being added to the
Okay.
plan.
So Phil, there's no sidewalk or curb waivers on this one?
No, I don't get
No, We actually are complying.
Thank
No,
you.
shocking.
Okay, good, good.
We had originally asked for a waiver for curbing, and we withdrew that.
Okay, that's good. So people can actually walk on the sidewalk?
Right.
Okay, that's great. Okay. And then the last one here says motor vehicle parking facilities is, what are your requesting a
Right.
waiver on that?
So often you have a planting strip that's required adjacent to the building. We have bollards for safety reasons.
Okay, we're okay with that. Okay, that's it. And then the final one, design criteria, it says the applicant requests a waiver for the proposed RCP, and he supports this action, but what is that?
That's the normal, what we have all the time with
The pipes?
The pipe is going to be a PV, of high density poly.
Okay, yep.
The plastic.
As opposed, yes, okay, I understand. Yeah, we see that a lot.
And
Okay.
then I will I'll note at the bottom, page 3, you can see with the pre and post-development flows, as a percentage, we're at every interval, the 100-year, the 50-year, the 25, 10, 5, and 2-year storms, we are more than halving the storm flow as a result
Okay.
of this.
Well, I think he's done a nice job. It's a nice little building, and
Okay.
I think it's going to improve the area. And like you said, he's the neighbor anyway, so
Yep.
won't get complaints from his neighbor. But now it looks like it's going to, you know what type of, is it a medical building or just a general office building, or?
Well, the second floor, Dr. Sandy can.
Thank you, ladies and gentlemen. So this building has 2 floors. The upper floor is our office, Punjab Towing Office, has 2 employees.
Okay.
And most of them, the one is manager, he's off-site, and basically comes to collect the paperwork or deliver some papers.
Okay, good.
And the second person is a clerical worker, and
Yeah.
he works from home many times. So it's hardly maybe 1 or 2 persons working there at the most.
Okay.
The lower floor, we think we want to rent like insurance company or lawyer's office.
Okay.
So the minimum traffic flow and minimum parking requirement.
Okay, great. All right, that's good, that's good. Okay, does any of the other council people have a question for
I
Mr.
do.
McGinnis or the engineer? Go ahead.
So behind it, I don't know, the apartments are behind it. Are, in terms of planning, I know we're not doing anything in the front,
Yep.
but since you're making this look so nice, and I appreciate that because we do drive by it all the
Thank
time. Is there anything going on to the back of it in relation of any plantings or anything on the back side? Excuse me.
Sorry. The existing vegetation is going to remain in the rear, except for the only thing we need to do back there is a small bit of trenching to connect to the sanitary sewer line.
So you can't plant anything, is what you're saying?
Well, the existing plantings that are there, the existing growth that is there is going to.
Is there trees there now, or woods or bushes and stuff?
Yeah.
Is it maintained, or is it just brush?
It's a mix. I mean, it's natural art, so there's some trees, different sized trees, and there's underbrush as well.
And that's something I'm sure, as the building's constructed, we can make sure it's maintained appropriately. Over the years, as I was discussing, some of the issues that this property had, with a nice new building there and hopefully a good tenant coming in on the first floor, there's extra incentive.
Right, so we want to be good neighbors to the people behind you, too.
Correct, yep.
Okay?
So if you can put the trees in there, you're going to put
There's
the trees
something.
in as opposed to in lieu of, correct? That's what you're saying?
In the back.
In the rear,
Yeah.
we'll make sure it's vegetated.
Or even if there's a fencing that can go up to
Appropriately.
shield people, because if you're having cars coming in, and depending upon what time the trucks might come in to take out the trash.
Yeah, we can
even
work
if it's
with
a
Full and
private
to make
event
sure
or
that
something to
right,
put
it
up
looks-
to shield the apartments.
Yeah, we can make sure it looks
If you
nice.
take out some brush, maybe you can stick a couple bushes in there or something.
Yeah, just thinking of like the Mackyard, it's easier to keep up with. You're on a busy road at Knights Road. You're surrounded by apartments, gas stations, shopping centers right nearby. We see a lot of trash just gets blown into those sort of areas. So having something that's more well-maintained and less brush is going to look much nicer.
And I understand not in the front, but
With all nice,
I'm sorry,
Yeah,
not asking for
your
representation.
interpretation of brush is what? I mean, California did too well with their brush.
That's a good point.
Over
Yeah.
in California, heat rains a lot, so.
Well, they're agreeing to clean it up, right?
Yeah,
Per
yes.
Phil's.
However, we'll work with Phil and we'll make sure they're comfortable with the vegetation plan to the rear.
We frequently do that during construction. When we see there's areas that you can plant, we recommend that they plant, and they always do.
And we know it's a commercial use that abuts a residential corridor, so always mindful.
Okay, thank you.
Thank you, Mr. Guest. Thank you.
Thank you.
Always a pleasure.
Okay, is there anybody from the audience that would like to speak for or against this applicant? Because it is preliminary and final land agreement, it hasn't gone on a lot. I think it's going to clean up the area. I think this is professional people coming in, which is good for the area too, hopefully a job or two. Okay, if not, if there's no questions, does anybody want to put a motion forward? Now, there's particular waivers that we need to get in, right? Mr. McGinnis?
Yes.
We always discuss them, so whoever makes the motion, make sure that you add waivers that we discussed. Okay, does anybody want to make a motion to approve the preliminary final land development?
I'll do a waiver for tax parcel.
Do the
Not a
motion?
waiver, I'll do the motion, sorry. It's been a long evening.
Okay.
For tax parcel 02036-245, located on Knights Road for Penn Petroleum LLC. So a waiver for a fee in lieu for 201-106 where needed, Section A, and 201-106B, a waiver for grades closer than 3 feet. Section 201-112A, a planting strip, and putting bollards instead in front of the building. And 196-61, a waiver for the types of drain pipes. And the impact fee will be paid as noted.
Yes.
Okay, is there a second on the motion?
Second?
Second, all in favor? Aye. Any against? Okay, so we have 5-0. Okay, congratulations, sir.
Thanks.
And thank you for investing your money in our community. Okay, and hopefully it'll be a beautiful building.
We appreciate your help. Thank you.
Thank you very much. Have a good
Okay.
night.
Yep.
Thank you. Always a pleasure.
Okay, number 9 on the agenda, Mr. Polari's stepping out, but he said the next couple were okay with he'll be right back. Number 9 is, agenda is consideration of a resolution authorizing certain individuals to execute and deliver such documents may necessary to discharge the township's obligation with respect to the appointment of Truist Bank as agent of certain financial assets. So apparently we have, Mr. Pazzo, we have assets in reference to our trust fund that need the name changes.
Yes, as you're aware, with the retirement of Mr. Samori as the Township's Director of Administration, Truist has requested that the Township provide it with an updated resolution as to who the authorized signatories are in regard to the Township accounts that they hold. This will just confirm, as was the case before, that the mayor and Mr. Chakowski remain as signatories. As Mr. Samori has retired, he will no longer be a signatory, and therefore the resolution reflects that fact as well. It's in a form acceptable to Truist, it's in a form acceptable to our office, and it's in a form acceptable for you to consider and sign this evening.
Okay, and then,
I put that in a form of motion, we accept it as presented, a resolution.
Second.
a second. Okay, and Mr.
All in favor?
Mr. Polari stepped away. We can still vote. He said it was okay. Is that okay?
Sure,
Okay,
there's
yeah.
a majority of you here.
Okay,
That's fine.
just want to make sure. Okay, so we have a first and a second. All in favor, say aye. Aye. Any against, any abstains? Okay. Okay, number 10 on the agenda.
Yes. Items 10 and 11, what I'm going to say to 10 also applies to 11.
Right.
Both of these are resolutions accepting municipal grant program contract with the redevelopment authority of the county in regard to their administration of the casino monies that the county receives each year for host fees related to that particular facility. Council has previously approved, and the administration submitted the requests for several grants. As council is aware, 2 of them were awarded. For item 10, this would be a resolution authorizing the acceptance of the municipal grant in the amount of $118,900. This is for the Bucks County Police Chiefs Association Record Management System. This is an ongoing grant that has been requested and awarded for several years now. Bensalem works as the lead agency on this. All 39 municipalities in the county are a part of it. The paperwork and the contract are in the form as is consistent with the program and is in a form acceptable for your consideration and approval this evening for the acceptance of the grant.
Okay, thank you. And can we vote on these as individual 10 and 11
Sure.
separate? Okay, so number 10 for the Bucks County, the County of Bucks County, the amount of $118,900 to the Bucks County Police Association record system. Is there a motion to approve?
Making motion to approve as presented?
Okay, is there a second?
I'll second.
All in favor? Aye. Any against? Okay, so we're good for nothing. Okay, so number 11 is the consideration of the municipal grant for the redevelopment authority to the county of Bucks in the amount of $165 regarding the Towns Against Graffiti Is there a motion to approve?
Make a motion to approve as presented.
Okay, is there a second?
I'll second.
Okay, all in favor?
Aye.
Aye, okay.
165,000, Jeff.
165,000, I'm sorry.
165. And again, the township is the lead agency for this. It's a multi-jurisdictional program that, as you all know, the mayor started some 30-odd years ago and continues to reap benefits for our community and neighboring communities as well.
Okay. Number 12 on the agenda is a resolution for Act 537, which is the standard thing we do. It's a new construction home on Pennsylvania, for PA Sewage Facilities Act, for land development of a parcel identified as 6067 Washington Lane. Mr. Pizzo, do you have anything else to say about that, or?
No, this is the standard documentation from the Pennsylvania Department of Environmental Protection for an amendment of the Township's Act 537 plan related to the addition, for the construction of the house at 6067 Washington Avenue. The form has been reviewed by the administration as required by PennDOT. Bucks County Water and Sewer has signed off, and it is in a form acceptable for your consideration and approval this evening.
Okay, is there a motion to accept the resolution for the Sewer Facilities Act?
I'll put a motion on the floor.
Okay, is there a second?
Second.
Okay, all in favor? Aye. Okay, so that's not good, 5. Okay, now we have some releases here. I guess, Joe, you're going to be handling these two?
No, that would be Mr. Worcester.
Oh, Mr. Worcester is the releaser, okay. That's good. Okay, consideration of 4 escrow releases. The first one will be Gibson Holdings of $24,088.
That's correct, Mr. President, and the remainder is $58,098 that's still in the bank. I'd like to give you just a brief overview of what's been done. 1515 Gibson, all 6 lots are built. They need to close out the PennDOT work. They need a wearing course on the driveways and the roadway. A few trees need to be replanted. Grading work and adjustments need to be done as well. And they will be generating a punch list for them to correct when the weather permits.
Okay, so you guys are recommending that we release the $24,088?
Yes.
Okay, is there a motion to approve Gibson Holdings A for $24,088? Is there a motion to approve?
Make a motion to approve item A at 1515 Gibson Road Holding, tax parcel 2545, in the amount of $24,088.
Okay, so a second? Subject to the...
Subject to the finance
Audit.
office audit.
Okay, is there a second?
I'll second it.
Okay, all in favor? Aye. Okay, nobody against? Okay, number B is the Federation Housing, Mr.
Yes, these two are tied together. The first one is from January 10th, since we didn't have a meeting, where we moved this one, as well as a second request for escrow for Federation Housing. The total amount of releases would be $157,160.33 for the first one, $132,990 for the second one. Some of the highlights associated with that is framing is underway on the building. Parking lot's partially stoned, but there's no paving yet. And they have been doing site improvement work like sidewalks and things that are outside the active construction area.
Okay, and we have enough money to handle what else has to be done on the property?
Yes, the remaining balance after these two will be $968,000.
Okay, that's good. Okay, so can we do both of these, Mr. Pizzo, at the same time, since it's the same person?
Federation.
Certainly. Okay, so, okay, is there a motion to approve Federation Housing, release number 4 and release number 5, written as B and C?
I'll put a motion on the floor as presented, once verified by the finance department.
Okay, is there a second?
Second.
Okay. I don't know who got that, actually. Ed got that. He's quick on the draw. No, that's all right. You got it. You were louder and faster. Okay. That's it. Okay, so that's done number 13. Okay, number 14 is public comment. There's not many people left except Frank. Is there anybody who would like to come forward for public comment? Okay, so seeing no one come forward, we'll close public comment. Other business? Mr. Worcester, do you have anything to add?
No, sir. Thank Mr. Pizzo for helping me out with my wording earlier today. And I was going to save a Go Birds cheer for him, but since he left his seat, I'll just say Go Birds.
Yeah. We were confident that you could actually spell Eagles. I think that's we're for sure. Okay. Do you have any? Go Birds. Go Birds. Okay. Okay, we have our legal team down there. Ken, do you have anything that you would like to add?
Nothing further.
Okay,
Go
Miss.
Birds?
I support the Eagles.
Okay, Mr. Pizzo, do you have anything to add?
I need tickets.
Need tickets? Yeah. Do you need tickets?
Go Birds.
They're about $8,000 a piece on the, whatever that StubHub is.
I need tickets that aren't $8,000 a piece. Go Birds.
That's what they are, $8,000 on StubHub. Okay, beyond that, Ms. Champion, do you have anything to add?
Go Birds.
Go Birds, okay. Is that it?
No, yeah, that's it.
Okay,
I'm quiet tonight.
you're quiet. You were very quiet. Okay, Ms. Benitez, do you have anything?
Building a Better Bensalem together had a successful Unity Week last week. We did have to cancel a couple of the events due to weather, so breakfast is rescheduled at Parks for February 17th. Mark your calendars.
That's right. Yep.
The Facebook page and website should be updated with the information. Registration is required. Yeah.
Yeah, we are registered.
Yeah, we're good.
Yeah.
We're good. And I just have to send my thanks to the Bensalem Police Department. There's a lot that we deal with because of lawlessness in other surrounding cities, and we handle it appropriately. And I'm very thankful for that. I'm thankful for your skill and for showing up for us every day.
Okay, thank you. Mr. Blair, do you have anything to add?
Go Birds, go Flyers.
Oh, the Flyers are still playing, aren't they?
And how many days till opening day, Deb? Just because facilities and pitchers are like 20 days away.
They won a couple, Flyers won a couple in a row. They got good young players, actually. Mr. Kisselback, do you have anything to add?
I think the most important day coming up is February 2nd.
February 2nd,
The
which is,
most important day coming up is February 2nd.
and go ahead, why?
Most important, there you go. Very good.
Aren't they
Very
missing the
good.
groundhog or something I heard?
It's
on the news?
Groundhog Day, right. Great movie, and a great movie, too. A great movie at that. That's all I have to say. Other than that, good meeting, nice and long, just the way we like it. And that's about it. Thank you.
Yeah, and so that's all I would like to add is that, I want the Eagles to win the Super Bowl, of course. And we have great fans, and we'll be able to control ourselves during our celebrations. And like Ms. Benitez says, unfortunately, we had a very difficult situation in our community, and our police handled it with professionalism. And unfortunately, a person was, his life was taken, unfortunately. But the community was safe, our police officers were safe, and nobody else got injured. And with that, we're thankful for their professionalism and the training that they received and acted on. Okay, with that, we have our next meeting is February 10th. Okay, February 10th, good night, thank you.